looked at. Now, kindly appreciate, and again, my little senior friend made these points, this official by email cannot be binding SAP Germany. Kindly see the reach of what the group company doctrine in that sense may be proposing. And there will be examples and examples. I confess that there are some hard examples, and there would be examples across the range. There would be, in a sense, a use of the group company doctrine. There may be a misuse of the group company doctrine. But the doctrine as formulated may not be susceptible to this kind of use or if I may, misuse. Because performance is, when do we say the company has performed the contract? In Dow Chemicals, the other entities of Dow Chemicals were actually distributing goods through that distributor, Saint-Gobain. It was that corporate entity that was actually doing the distribution. It wasn't some parent company's official who just stepped in, if I may. And the same test would apply for negotiation. Is often in negotiation, you would someone from the parent company may also come in Dow Chemicals. But the ultimate test is, if that parent company was going to be bound by the contract or the arbitration agreement, I appreciate those are two separate inquiries. Why would the parent company not sign that contract? Or sign, or by an exchange of letters, or by incorporation, incorporate that arbitration agreement? Now, kindly see again, how does a parent company contract out of this? Other than its subsidiary signs an agreement. That agreement is an entire agreement. That agreement says it can be amended only in writing between the parties. Now, in that context, how is the parent even to contract out? Because it is never contracted in, is my respectful submission. So, I want to say, although I am contesting the group company doctrine, it is actually because I am not in that pro-arbitration. Unless there is clarity on who the parties are. Of course, Section 7 will come up for interpretation in cases before this Honorable Court and in other cases. But that Section 7 itself provides the clarity. Within that also there can be context. But the group company adds a layer of uncertainty without, in my respectful submission, any statutory basis. And the further submission I will make is that the Arbitration Act or the arbitration procedure should be agnostic to whom are the parties. It should not be, that if I take my arbitration to the ICC institution, I get a different result as to who are the parties. Whereas if a party files a suit and a Section 8 is filed, a different result comes. Or under Section 11, a different result comes. And I would not submit that this interpretation, this application of the group company doctrines may in some cases lead to that kind of contradiction. Where, if it's a SIAC arbitration, a different result would ensue, whereas if it emanates out of India or in a second, a different result may ensue. And all this is also very relevant in the context of the Law Commission report. And the Law Commission report recommending the amendment to the definition of party and that amendment not being taken into account. But you should be aware that in the same Law Commission report also recommended the amendment to the definition of an arbitration to include the order of an emergency arbitrator. Emergency arbitrator in his public nicely commented in his emergency award that was not implemented by the central government because that would be like gilding a lily. The arbitral award always involved in emergency. But this would not be such a thing. Here, definition of party that does not include the words claiming through one. We have a definition of party that is different from the English article, which too does not accept the group company doctrine, despite that broader definition of party. Even there, the group company doctrine is not accepted. With that preface, and just 2 or 3 illustrations with this. Raised, I think, a basic case where it comes up, but agreement between a principal employer and a contractor, and the contractor in turn subcontracts various aspects of his work. Now, both these agreements have separate arbitration clauses. In fact, when we appear for a contractor, sometimes there is no defense to the principal employer because our subcontractor is indeed delayed work. It sometimes becomes a difficulty when you're appearing from a contractor sandwiched in that sense between a principal employer and a subcontractor. I'm sorry. But in my respectful submission to two separate contracts with two separate arbitration clauses. And therefore, the arbitrations would have to be and so the last aspect of my submissions will be judgments which have followed. Because in my respectful submission, Amit Kalchan may have gone one step too far where there were not even group companies where it was brought in. And so too MTN, where Cancina was not a party to the arbitration agreement. I'll briefly take you through that. But Cherin was correctly decided because Cherin was deciding a case of Section 35 and when a person would be bound by an arbitration agreement. And there, Cherin, and I'll show that, was a clear nominee of the person who had signed the agreement. Cherin, bought the shares as a nominee. And similarly, the decision in ONGC versus Discovery was correctly decided for this reason, that ONGC was seeking to bring in a party on the basis of alter ego. Therefore, Mr. said that before you decide the Section 16 application of that party, you must hear ONGC's application for discovery of documents. Similarly, in that sense, the result was, in my opinion, the correct result. He said, established that the counterparty to my agreement the law of one hour and seek to impede in this arbitration. So the judgments that follow. Now, with that broad preface, my lord, and only because I'm the first to be arguing, my lord, against the group company doctrine as it were, my lord, I have also, my lord, and I will make submissions how it narrows. But in the first instance, respectfully, the approach I would not commend to your lordship is that the very text in the reading of sections, your lordships would not deal with use of so fine the application. But just 2 or 3 words. No.
Now you really, because you are the first person who's saying that, well, don't apply the doctrine at all.
Yes.
So maybe we can come back at 2 o'clock.
But,
tell us what is your estimate?
Both of
so what much time would you like?
Both felt we need an hour and a half each, will over into tomorrow.
So because you start at 2 o'clock, then at 3:30 you should be done today.
Yes.
And
then your lordship give us time tomorrow. Otherwise, we had agreed we would share time.
And then
tomorrow.
But 3:30.
Yes.
Then you start at 3:30, and then you can finish by about say 12 o'clock tomorrow.
I think that should be okay. That will be fine.
And then that wraps up. Nobody else on this side, right?
Mr. Ghosh wanted to make just additional submissions, if at all. Sanjoy Ghosh. And that's it on this side. And I don't think
he's not here, but
because we are rising. Because if Thursday is declared as a miscellaneous day for some reason, then tomorrow we'll have to wrap this up. And then we'll be able to wrap it up because the others then can give us a supplementary note or something.
501.1 minutes we want to address.
Yes. Thank you. Thank you.
Check.
Yes, Mr. Rai.
Lord, I had said I would briefly just touch on Dow Chemicals, just to explain its context, and then directly come to the chloro control. Dow, your Lordship has seen, my Lord, the distribution agreement designated Dow France for the delivery of the products. So, my Lord, one of the non-signatories, as it were, Dow France, was designated in the agreement itself as one of the persons who would distribute the products. And therefore, my Lord, we don't know all the facts because this is, of course, a redacted version of the award. But Dow Chemicals, France, as that legal entity, was distributing products to Saint-Gobain, the distributor. Now, my Lord, it would stand to reason that that would be done through some written agreement. From time to time, the rates at which the goods were sold, the terms on which the goods were sold would either relate back to the distribution agreement or would otherwise have some terms. It's not in that context that an intention is gleaned to adopt the arbitration agreement contained in that distribution agreement to Dow France. But I hope I make myself clear, my Lord. This is, your Lordship has not put examples of legal relationships which would be non-contractual. And there would be, my Lord, even in the corporate world, there would be some. I can't rule it out. But, my Lord, your Lordship may appreciate, my Lord, typically, in the corporate world, if a corporate entity is performing, it would be doing so on the basis of some writing. It would be acting under like a distribution agreement like this. Dow France would be distributing goods. Now, my Lord, it's in that context that this arbitral tribunal found, my Lord, that those non-signatories were also parties to an arbitration agreement. But, my Lord, because the facts, the more relevant aspect perhaps of Dow Chemicals is that the tribunal records that they are applying French law. And that's very critical, my Lord, because as I'll show, my Lord, French law has no particular form for an arbitration agreement. And in that context, perhaps these tests of
Yes.
And because Dow Chemicals, ultimately your lordships have to interpret our arbitration act. But I only wanted to, my Lord, endeavor to persuade your lordships that Dow Chemicals is applying a different legal regime, which specifically does not have the equivalent of Section 7 of our arbitration act. And perhaps in that case also, there probably was a distribution agreement and purchase orders or something akin to that under that distribution agreement. in addition to the non-signatory being specifically named as a party that would distribute the products under that distribution agreement. Look, and as I said, French law contains no particular form. Now, Manoj, I come directly to chloro control only to identify what are the contours of the group company doctrine as laid down in chloro control and where they derived that doctrine from or where they found it in our arbitration agreement. But if your Lordship comes to my written submissions now, I'll largely go as per that.
Yes.
Doesn't my Lords have it?
You want to refer to chloro control now?
No.
I'll refer to parts of chloro control and also my
Submissions.
Yes. But if your Lordship has first
one thing which the Nodal Council should have done was, in the earlier CBs, what they have done is that they have they've labeled the submissions A, B, C. So then it becomes easier for the council to say, okay, I'm on C2 or C3 or whatever. Otherwise, it becomes 1 second. I'm just trying to locate your submissions.
Respondent SAP, last one. Written submission. Morning respondent SAP.
This part goes like these written submissions set out the positions of respondent number 2.
I'm grateful. Yes, that's how it's about. I was placing chloro control. And my submission is that chloro control, carefully read, may actually be a case of consolidation of disputes.
Let's see how you formulated
Yes.
it. Can read through it.
Yes. May I read paragraph 3? of my written submissions. Does my Lord the Chief Justice have it?
Why don't we look at para 2 as well? You just take 2 minutes, sir. You have
Yes.
set out the facts. It just gives us the
Your Lordship has, my Lord.
Roman para 2.
Yes.
You're right. Para 3.
Yes.
You're right.
I'm
You're
sorry.
right. Para 3.
Heading para 2, Roman para 2. I'm sorry. Lord, I'll read it first and then explain my submission. In order to appreciate the group of companies' doctrine as involved in chloro control, it's important to set out certain facts of that case. The plaintiff in the suit, that is chloro controls, was undisputedly a party to the arbitration agreement. Several of the defendants were party to one or more agreements, and all the defendants consented to arbitration during the course of the hearing. Out of the 7 agreements executed between the parties, 3, including the parent agreement, contained an arbitration clause, and no party had commenced any other proceedings in respect of any of the ancillary agreements. So, the ancillary agreements had separate arbitration clauses, and no party had commenced arbitration under any of those. And all parties, all defendants consented to arbitration, even those who were not party to any agreement that contained an arbitration clause. On the basis of the above facts, the doctrine was evolved, relying on the term claiming through or under in Section 45 of the Arbitration Act. However, as the ancillary agreements were appended to or explicitly referred to in the parent agreement, this court also found that the dispute resolution clause of the parent agreement had been incorporated by reference as contemplated in Section 7(5) of the Arbitration Act into the ancillary agreements. This is, my Lord, extremely important because perhaps part of the reasoning of chloro was that relying on Section 7, the arbitration agreement contained in the joint venture agreement had been incorporated by reference into, my Lord, the subsidiary or subsidiary agreements, my Lord. But now I'll request Your Lordship just to read 3 or 4 paragraphs of chloro control to see how this doctrine has been laid out as distinct from what parties to an arbitration agreement are or can be said to, my Lord. If Your
Why
Lordship,
don't we actually complete reading this part?
Yes.
Then we can go there so that
Very
this
well.
part is over, isn't it? That's better. So that your formulation is clear to us.
Very well.
You know where this is.
yes, ma'am.
Para 5.
In chloro controls, the court noted that normally arbitration takes place between the persons who have, from the outset, been parties to the arbitration agreement and the underlying substantive agreement. However, arbitration with a non-signatory to the arbitration agreement and the underlying contract is possible if the non-signatory claims to or under a signatory. The court thereafter provided illustrations of a party claiming through or under, such as assignment, succession, novation, and piercing the corporate veil. The illustrations do not include application of the group of companies doctrine. And Your Lordship will kindly have, Your Lord, footnote 1. The illustrations where a party is claiming through or under, my Lord, would often be defined as parties in the agreement itself. Your Lordships have seen, my Lord, when a party is defined, it sometimes includes their permitted assignments or successors. The submission therefore being made, my Lord, is that these categories of parties or of persons would actually be parties to the agreement also in most cases. My Lord, for example, an assignment. A permitted assignee by the definition contained in the agreement itself will be a party to the agreement. And it was even, my Lord, in the Cheran Properties case. And similarly, my Lord, if a party succeeds to the rights of another party, my Lord, if there's a merger of 2 companies, the successor entity will be bound, not just by law, but by the contract itself. The contract would define party means X and its permitted assigns or successors. Similarly, my Lord, the test of novation. And finally, even piercing the corporate veil. Lord, if your Lordships are piercing a corporate veil, your Lordships are saying that although A has signed the contract, actually he can pierce the veil and go up to the parent of A. Similarly, submission is that these illustrations are, my Lord, of a different category than the group of companies doctrine. These would, my Lord, legitimately fall either as parties to the agreement or claiming through or under. But these do not include, my Lord, the group of companies doctrine. Then, my Lord, paragraph 6. In paragraph 71 of chloro control, this court recorded that though the scope of an arbitration agreement is limited to parties who entered into it and those claiming under or through them, the courts under English law have in some cases also applied the group of companies doctrine. Millard, I've put a footnote here also, Millard. I think it's common ground among all counsel, Millard, that this statement may not be entirely correct, that English law also does not recognize the group of companies doctrine. Therefore, according to Chloro Controls, the group of companies doctrine entails extending the reach of the arbitration agreement to persons other than signatories thereto and the persons claiming through or under them. While the illustrations set out in paragraph 70 of Chloro Controls would cover persons claiming through or under a party, the group of companies doctrine is something more. The court explained the doctrine as follows. An arbitration agreement entered into by a company, being one within a group of companies, can bind its non-signatory affiliates, sister or parent concerns, if the circumstances demonstrate that the mutual intention of all the parties was to bind the signatory and non-signatory affiliates. So, in the first instance, the test was laid out in paragraph 71 as one that has mutual intention. It was based a lot on intention. Thereafter, para A, Chloro Control provides two alternative bases for invoking the doctrine. These are: the underlying transaction is with the group of companies, and there is a clear intention to bind the signatories as well as the non-signatories. This is again without intent. The second broader formulation was, despite the non-signatory not having consented to being bound by the arbitration agreement, it is joined as a party to the arbitration. If it has a direct relationship to the signatory party, there is direct commonality of subject matter. The agreement between parties is a composite transaction, that is, performance of the mother agreement is not possible without execution and performance of ancillary agreements, and such joinder will serve the ends of justice. It is not this second formulation that was perhaps extended in Amit Lalchand to even a non-group company situation. And in my respectful submission, the group of companies doctrine is a bit of a misnomer. Because if your lordship finds intent to arbitrate, then group company or not,
It's a contract.
a party would be bound.
It's a contract then, because once there's an intent,
Yes.
then the question is, what is the evidentiary test for finding the mutual intent?
Yes.
Then Mr. Kambata just argued in the morning that, well, it has to resolve itself into a contract.
Yes.
In terms of sections 7 and 13.
And the fact
It can't be really just an intent dehorse any written contract between the parties or written pleadings or written correspondence in view of our section 7.
And in the context of group companies, that may be one indicia, that may be one indication. But ultimately, the test would still be, is there an arbitration agreement formed as contemplated in section 7? And that's what I'm saying, in some senses, the group company doctrine is broader than even the word suggests. I mean, it could bring in non-group companies also. So the fact that it's a group company is one indicia, but it need not be limited to group companies alone. If there is a document incorporated by reference, even a non-group company will not.
Actually, even point number 2 can resolve itself into mutual intent, you see.
Yes.
For instance, if you say that, well, there's a direct relationship with the signatory party, direct commonality of the subject matter, the agreement between the parties is a composite transaction.
Yes.
The performance of the mother is not possible without the execution of the ancillary agreement. Possibly there are elements of intent here also, but then the court goes and says that such joinder would serve the ends of justice.
Yes.
It's almost like an Order 1, Rule 10.
And that's what I was saying. Is a problem arbitration law faces as to necessary and proper parties. That is really somewhat at the heart of this dispute, of this issue your lordships are also dealing with. But ultimately, there may be no easy solution when parties have expressly not entered into an arbitration. But I'll just develop that and Section 8(3) of the Arbitration Act, which hasn't been dealt with in detail as yet. But your lordships are right, Lord. Order 1, Rule 10 would apply to civil court. But it may not apply, or in my respectful submission, it ought not to apply, Lord, to bring a party that is. And again, Lord, I'm prefacing all this by saying that would be, in a sense, not defeating the sanctity of arbitration agreements and an arbitration law more generally, Lord, because it is founded on consent. And your lordships have not expected that once there is an arbitration agreement, your lordships will give full play to it. The courts will not intervene except to the limited extent provided in the Arbitration Act. In Section 34, your lordships have laid down an extensive jurisprudence.
So the essence of arbitration is that parties will enter into an agreement.
Yes.
With regard to who.
Yes.
They will resolve their disputes through a private forum as opposed from a public forum.
Yes.
That's the essence of arbitration.
I'm very brief.
It's not just that I, as a contracting party, want a private law forum as opposed to a public forum in the form of a court, but I also define with whom I want to enter into that transaction for a resolution of disputes through a private forum as opposed to a public forum.
I'm deeply obliged, Lord.
So it's not just the choice of the means of dispute resolution, but the choice of the parties with whom I will have that form of dispute resolution. In a court, that is not so.
Yes.
Court, the distinction between court and arbitration arises only in terms of that a court is a public forum.
Public forum.
There's no choice. Section 9 CPC.
Yes.
Or 226 or 30. There's no option. Once one party goes, other has to come and the court will exercise. In an arbitration, you are choosing the forum.
Yes.
That's the point of distinction.
Yes.
You are choosing the forum, choosing the person with whom you will have the forum.
I could not have put it better, but that's the heart of my submission. That when your lordships find
Second part of
parties have.
I'm
grateful. Yes.
Whether you can go beyond the written parties or not.
Yes, and I'm submitting, my lord, and I hope to develop it. That exactly what, my lord, your lordships are putting to me, my lord. It's not just the choice of forum, but it is whom you will arbitrate with.
In a very about the kind of person they would like the matter to be adjudicated.
Yes. Therefore, all aspects. First of all, who will I arbitrate with? And then who will my arbitrators be? As I said, my lord, in my two agreements, the first agreement, my lord, specifically says that the chairman shall be a solicitor and the other arbitrators shall have a background of training in computer law, computer science, or marketing of computer industry products. Now, can this be clubbed with another arbitration that has a more general arbitration clause? I'll come to that, my lord, because that will raise serious concerns with regard to how institutions conduct their arbitration. Lord, and I'll come to those rules, because at the heart, my lord, as I try to submit, is some issue of joinder.
So it's layered, actually. Parties agree, firstly, that they will not go to court.
Yes.
But that they will go to an arbitration. Second, they will decide who will the adjudicator be in the private arbitral forum. What will be the qualifications for that arbitrator? You're not bound to select anybody. You can say, well, I'll have only a chartered accountant. I'll have only a structural engineer. I'll have only a whatever. You can define the person who's going to. So you have a choice of forum, the exclusion necessarily of the court. Second, the choice of the adjudicator in an arbitration. And third, that you will also be entitled to define who will you arbitrate with.
Yes. Yes.
That we will not agree to an arbitration beyond this set of parties.
Yes. And
for whatever reason.
Yes. My lord, I'll come to it, but since your lordship is putting it to me, my lord, those persons you are going to arbitrate with have certain rights under the arbitration agreement to, for example, nominate arbitrators. To take a simple example. Now, when you're not in the group company doctrine, if parties are added, what happens to the rights of those parties? I hope I make myself clear, my lord. My lord, I'll show that through reading, my lord, the standard arbitration clause. Really, what is happening is an implied term is being read in, where in place of parties, the words are being added parties or certain group companies.
Mr. Rai, therefore, the point, really the compass is twofold. Either we jettison the doctrine completely, which is your broader point, or alternately, we so structure it so as to bring it within the comport of our Arbitration Act.
Yes.
If we have no choice but to jettison it, certainly. But considering the fact that, the doctrine has held a field and has worked itself out now for a decade, the other option is to sort of define the contours.
Guardrails.
And guardrails, as Mr. Sambata said.
Yes. Lord, I'll endeavor to, Lord, even to, as your lordship defines the guardrails, Lord, I'll make my submissions on 8 and 45 and 7 so that those guardrails can then be correctly laid down, Lord, as per my submissions also. But your lordships are right, Lord. If your lordships find that the group company doctrine has a place in Indian law or in the Indian Arbitration Act, then a reading of section 7 and 8 will at least lay down the correct parameters for that doctrine.
All right, let's complete reading this 9 and 10 now.
Well, at paragraph 9, the court concluded that though not all parties to the list are signatories to the arbitration agreement, they would be covered under the expression claiming through or under, as their interests are not averse to the interests of the principal company, and they derive their basic interest and enforceability from the parent agreement, with the other agreements falling in line with the contents of the parent agreement. Now, your Lordship has dealt with this expression in Charon Properties, where we're not claiming through or under, or in that context claiming under, is you have to claim in the same identity as the persons to whom you're claiming. Chloro control places it as if there is a joint venture agreement and the signatories are signatories to other agreements under the joint venture agreement, a distributor agreement or a trademark license agreement. They are claiming through and under. That may not be with respect to correct test. You have to be claiming through or under the party, not through or under some agreement. And this becomes important because these agreements are the result of complex negotiation, of course, have their own separate arbitration agreement. And these entities tomorrow could be outside the group company also. Tomorrow, these entities could be sold by the Severn Group or the Chloro Group. They are always not separate legal entities entitled to their own rights under their respective agreements.
Let's quickly now go on to point number 3. This is your attack on Chloro now.
Yes. But may I just go directly to point number 5 first and come back?
Point number 5?
Yes, that is at page 6. I'll just deal with Chloro, and now I'm dealing with whether this doctrine can be found in 8 or 45, and then I'll deal with whether it can be found in...
Actually, why don't you read you've done it properly, actually.
Yes.
No? Let's go back to your Roman 3.
Yes.
You've evolved it logically.
Yes, very good. But what I've tried to submit in Roman 3 broadly is...
Let's go read.
Yes, arbitration is based on consent and party autonomy. But section 9 of the CPC provides that all civil suits shall be subject to the jurisdiction of courts, except where there is an express or implied bar. As held in Dhulabai versus Madhya Pradesh, jurisdiction of the civil courts is all-embracing, except to the extent it is excluded by an express provision of law or by a clear intendment arising from such law. An ouster of the jurisdiction of a civil court is not to be lightly inferred. I don't need to place that judgment. I've just extracted the relevant principle. Because this is the guiding principle which ousts. Yes. Section 5 of the Arbitration Act contains that bar to the jurisdiction of civil courts. It ousts the jurisdiction of civil courts in matters, Lordship may mark, governed by the Arbitration Act, except where the Arbitration Act so provides. Lord, the submission was that Section 5 ousts the jurisdiction of civil courts in respect of matters governed by the Arbitration Act. Therefore, to say that there is no inhibition in the Arbitration Act to this doctrine may not be sufficient. It must actually be found in the Arbitration Act, because ultimately it ousts the jurisdiction of civil courts. And how does the Arbitration Act govern it? Is the parties' agreement to arbitrate.
The first sentence is important, para 13.
Yes, the parties' agreement to arbitrate as a condition to the ouster of jurisdiction of a civil court is therefore essential.
Which is section 28 of the...
and section 28 of the Contract Act. Once the clear intention to arbitrate, as expressed in an arbitration agreement, has been identified, then arises the concept of party autonomy, which has been recognized as the cornerstone of arbitration by various decisions of this court. Given party autonomy, parties are free to choose the seat of an arbitration, the number of arbitrators, the procedure for appointment of arbitrators, the rules governing the arbitral procedure, the institution which will administer the arbitration, subject to the disputes being arbitrable under the law applicable. However, party autonomy is premised on the autonomy of a person to choose to arbitrate, and with what my Lord the Chief Justice was putting to me. It is in order to ensure that the ouster of national courts is not lightly inferred in favor of a dispute resolution by a private forum, and to give primacy to consent and party autonomy, that the Arbitration Act prescribes the form an arbitration agreement must take. And my Lord, I have footnoted the decision in Charon Properties versus Kasturi, paragraph 24. That's my Lord footnote 5 of my submission. I could read it, my Lord, if your Lordship wants me. Your Lordship have not laid down exactly that principle. Then, paragraph 15, where commercial entities and persons of business enter into dealings, they do so with the knowledge of the efficacy of the arbitral process. The commercial understanding between parties is reflected in terms of the agreement between them. The duty of the court is to impart to that commercial understanding a sense of business efficacy. And there, my lord, I rely on your lordship's decision in IS1. But again, my lord, it is premised on a determination that parties have chosen to arbitrate and with certain other parties. Now, my lord, I deal first with section 7 and then with 8 and 45. The group of companies doctrine cannot be read into or from section 7 of the Arbitration Act. Consent to arbitration must be expressed through an agreement in writing. In a departure from the ordinary rule applicable to contracts, section 7 requires that an arbitration agreement must be in writing. This written agreement between the parties must be to submit all or certain disputes which have arisen or may arise between the parties in respect of a defined legal relationship, whether contractual or not. Section 7.4 sets out that an arbitration agreement is in writing if it is contained in a document signed by the parties or in the form of exchange of letters or other means of telecommunication or electronic communication, which provide a record of the agreement, or in the form of an exchange of pleadings where the existence of an arbitration agreement is averred by one party and not disputed by another. So, Your Lordship had noted that it can happen even post the dispute starting by the exchange of pleadings. But my Lord, 7.4, in my respectful submission, would be, my Lord, exhaustive of the kinds of arbitration agreement and what it means for an arbitration agreement to be in writing. I'll try to explain a little later. While it is true that courts adopt a pragmatic and not a technical approach while construing an arbitration clause, this is only to the extent of not insisting that the agreement be in a particular form and not allowing the agreement to be defeated due to errors in drafting, such as misnaming of the arbitral institution or use of a particular nomenclature. In such cases, the court seeks to give effect to the intention of the parties. And these are, my Lord, decisions that I've cited, Prickall and Govind Rubber. However, when the intent itself is absent, in that it has not been expressed in writing, a court cannot infer intent to create an arbitration agreement. And similarly, an arbitration agreement cannot be created based on the implied consent of a party or by reading into the contract an implied term. Or, my Lord, one learned friend on the other side said, my Lord, an implied written agreement. That would be a contradiction in terms of my submission. It would be apposite to refer to Section 9 of the Contract Act, which deals with implied promises and stipulates that insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. Considering that Section 7.3 of the Arbitration Act states that an arbitration agreement shall be in writing, the question of reading implied consent into an arbitration agreement to bind as non-signatory does not arise. So, that's why I submit, my Lord, that an implied consent, Section 7.5 certainly provides that an agreement can be incorporated by reference. But an implied consent may not, my Lord, fall within the requirements of Section 7, which define, my Lord, that an arbitration agreement should be in writing. But, my Lord, this takes us into an area that perhaps has not been covered earlier, because really what is happening if an implied consent is being read, then an implied term is also being read into the contract, into the arbitration agreement at least, for the first instance. Perhaps even in the substantive underlying contract, but certainly in the arbitration agreement. An implied term is being read that some other persons are bound by that arbitration agreement. And that's what I'm going to try to lay down the test in Nabha Power. In Nabha Power versus Punjab State Power Corporation, this Honorable Court has held that courts may imply a term into a contract only if all the following conditions are satisfied. It is reasonable and equitable. It is necessary to give business efficacy to the contract. It goes without saying, and it is capable of clear expression, and it must not contradict any express terms of the contract. But if I may just pause here for a minute and explain this point. Your Lordships have not an arbitration agreement, a typical arbitration agreement, that says any dispute or difference arising under this contract between the parties hereto shall be settled in accordance with the following procedure. And typically it says that party A will nominate, party B will nominate, and the two nominees will appoint a third person. Now, my Lord, what is happening perhaps by reading in an implied consent is that arbitration agreement is being now subjected to an additional term, an implied term. And to do that, the test would be much higher than just business efficacy. It would be not these tests laid out, this Penta test in Nava Power, which is that an official bystander test, that anyone sitting in the negotiating room, if asked, is this non-signatory a party to the arbitration agreement, would say, but of course. That is how the test has been first put down. That someone would say, but of course, there is no doubt about it, that a parent would also have agreed to be bound by the arbitration agreement. And I'm placing it a little high because your lordships are dealing with a range of situations which this doctrine will apply. But in the context of modern corporations, group companies, group structure, it is hard to conceive how an employee would be able to participate in a negotiation discussion and bind the company itself, absent it being a signatory to it. I place that because, again, Mr. Khambata has taken your lordships through the provisions of the Companies Act. Ultimately, a company will act through its board of directors. And a significant agreement would have to be authorized duly and signed. It would be very hard to imagine a situation where an employee would be binding his company without actually signing the contract. And that's why I tried to give an example of a arbitration clause in footnote 13, which is an arbitration clause between parties, the end of the second line. It's between the parties in footnote 13. And what is happening is parties are therefore being added. An implied term is being added that it's not just parties, but parties and certain group companies. The other aspect which involves a layer of complication is where a group company has signed a separate agreement with its own arbitration clause, then that arbitration clause is being negated and the arbitration clause in the mother agreement is being given effect to. There are two situations. One is where the group company has not signed any other agreement or arbitration agreement. That may be one class of situations. But the other class is where that particular group company has specifically entered into an agreement with its own arbitration clause, as was there in flow control. Now, that arbitration clause is in effect being given a go-by. In effect, that arbitration clause is being given entirely a go-by, and that party is being told that you have actually acceded to or agreed to the arbitration agreement contained in the mother agreement. So, one of the guardrails I would respectfully submit is that even when applying this group company law, where a group company has entered into a separate arbitration, that arbitration agreement, where it has entered into none, perhaps mutual intent could be read to be part of the other arbitration agreement. But when the intent is actually expressed in a written agreement, including a written arbitration agreement, as was the case in Tribunal, that may be difficult to circumvent. Well, I'll read on from paragraph 8. It is ex facie evident that given an arbitration agreement in writing, which addresses itself to disputes between the parties, this Penta test is incapable of satisfaction. In effect, under the guise of business efficacy, the arbitration agreement is sought to be rewritten, ignoring the clear terms of the written agreements, which are, especially in multi-party, multiple contract situations, the subject of long and hard negotiations. And again, I wish to draw a distinction between when your lordships have deployed the principle of business efficacy to give full effect to an arbitration agreement from this anterior stage, where your lordships are examining whether there is an arbitration agreement, and if so, among which parties.
No, Mr. Rai, we're talking about business efficacy. What about litigation efficacy? There is another contract, consolidation of the proceedings. That would also require us to apply the principle. I mean, may not be in this fashion.
Yes.
But otherwise also consolidation, if it's relating out of same kind of a, we have to efficacy of the litigation is also a factor we have to take in.
I bow that observation. There is a challenge. There is a problem. The institutional rules also deal with this problem. They provide for consolidation of disputes where arbitration agreements are consistent with each other. Where, my lord, for reasons best known to the parties, they have agreed that a technology license agreement will be governed by the laws of, let's say, Germany, with the seat in Germany. But the trademark license agreement will be governed by another body of laws administered by a different institution. But the institutional rules would not permit consolidation. And my respectful submission, my lord, is that Section 8 is not a provision for consolidation. My respectful submission. Neither is Section 11. And in doing consolidation under Section 8, we may be affecting the institution's ability to run its arbitration as per the arbitration agreement with the parties. I bow down entirely to what my Lord Justice Roy is saying. There has to be, my Lord, litigation efficiency. But that is also in large measure something to be determined by the parties when they are negotiating. They may provide for how a particular dispute will be resolved if it involves all the parties to the joint venture agreement and the other subsidiary agreements. But ultimately, my Lord, the cornerstone of it may have to be, my Lord, the parties' agreement itself. And if they have chosen a unwieldy or unwise, in a sense, process, that is, my Lord, what they have chosen. My Lord, your Lordship put it well, my Lord, that there may not be a soft solution to hard negotiations. Ultimately, these are hard negotiations. And my Lord, oftentimes, I may say this, my Lord, with experience as being a corporate lawyer in my next years, there are reasons parties choose particular seats or particular institutions or particular applicable law. And my Lord, in certain instances, perhaps the Lord may not be respecting that choice as firmly as it should be. Paragraph 20. Further, it is a set principle of contractual interpretation that previous negotiations and declarations of subjective intent included from consideration while interpreting the terms of the contract. Section 90 of the Evidence Act states that where the terms of a contract have been reduced to writing, no evidence shall be proof of the terms, except itself. In Rup Kumar versus Mohan Thedani, this Honorable Court recognized the written liberation on the part of the contracting parties, and it is natural that they should be treated with careful consideration, and that wherever written instruments otherwise required or by the contract of the party, be the repository, any other evidence is excluded, be used as a substitute for such instruments or to contradict them. When the terms of the contract are clear and ambiguous, only the express terms can be relied on. Therefore, where an arbitration agreement clearly sets out the parties thereto and the arbitral procedure agreed among them, no intention to bind persons other than the named parties can be read into the agreement. Similarly, where the underlying agreement contains an entire agreement clause or a clause providing that amendments to the agreement, if any, can only be made in writing, the arbitration clause cannot be interpreted in a manner so as to expand its reach to parties not named as parties to the arbitration agreement. And I've just footnoted at footnotes 17 and 18, just an illustration about what an entire agreement clause looks like, and my Lord, what a clause with implications of the agreement shall be made except in writing. And my respective submission is, my Lord, to the extent, my Lord, the group company doctrine as formulated in chloro control, my Lord, and I'll come to a narrower or prescribed version of it, my Lord. But to the extent this group company doctrine as laid down in chloro control, it, my Lord, goes against perhaps the written agreement of the parties itself. Lord, as Mr. Lord, one of the tests that he laid down was that it should apply in reverse also. So a party can assert that it is a claimant under the, then it also has to be a defendant. In that context, Lord, I submit that you are therefore telling an opposite party that not just the party contracted with, someone else can also lay a claim against you. And that, my Lord, would be reading an implied term. But again, your logic, with a myriad setting, there may be standard form of contract where this issue may not arise with its full force. But where, my Lord, defining that only they will be subject matter of an arbitration. Then parties are in implied terms being added. Further submission was that if that term must be done on the principles of NABA. And again, we're speaking with all humility and some sense of responsibility, but it's hard in commercial contracts how that test can be, how it can not be contended. A parent sitting in the US tended to be bound by the other people without even signing. After my submissions on Section 7, I now come to whether this can be a principle found in Section 8 or 45 of the Arbitration Act. Before addressing whether the group of companies doctrine can be drawn from Section 8 or Section 45, the scope or nature of this proposal. Sections 8 and 45 are provisions in aid of arbitration. Right, how a judicial authority must act when an action is brought before it, that is the subject matter of an arbitration agreement. The provision is intended to ensure that if an action is brought on a matter that is the subject of a party or any person claiming through or under the party can parties to be referred for arbitration. This legislative intent is also clear from Section 40 and 41 of the Arbitration Act, with the words. But Section 8 and 45 are not which contemplate or can be read to contemplate the issue of persons has been found by the arbitration agreement. This is my respectful submission. These provisions do not purport to and cannot be relied on to alter the definition of an arbitration agreement as set out in Section 7. That the constitution of an arbitral tribunal or the parties to the dispute are matters separate from Section 8 is made clear on a reading of Section 3. 8.3 makes clear that notwithstanding the pendency of an application under 8.1, an arbitration may be commenced or continued, and even an arbitral award made. Lord, may I request your lordships to just read that one provision with me? This has not been placed. Lordships has under Section 8.3. Section 8.1, which is the application. Notwithstanding that an application has been made under subsection 1 and that the issue is pending, an arbitration may be commenced or continued, and an arbitration may be made. Now, consider a control kind of situation where without one party under agreement to which it is a party and that agreement has an arbitration clause. If it commences an arbitration under that agreement, before, for example, the ICC, it was the case in one of the agreements, then that arbitration would continue with her. In just those parties, I hope I make myself clear, because it is, again, I will endeavor not to see how one can resolve the complex situation. But this is one complexity of the other nature that arises. The party which has a specific arbitration agreement is being denied the full effect of that arbitration agreement. And this is all done after negotiations between the parties. And this is not, I'm making a submission based on 8.3. Based on 8.3, that a party can commence its separate arbitration. And I'm partly responding to my Lord Justice Roy's comment that therefore 8 is not a provision for consolidation. So ultimately, consolidation has to flow from consent of the parties or the institutional rules dealing. If their agreements are compatible with each other, the institutional rules will not provide for consolidation. But if you have neither consent of parties or compatibility of arbitration agreements, then there may be a certain and litigation inefficiency or dispute resolution. Separate from, I'm now on Roman 6 of my submissions. Separate, my lord, from an understanding of the scope of Section 8, that it cannot and ought
It's
not
more
be
or less the same.
Yeah.
5 and 6 are more or less the same.
Yes. But 5 and 6, my lord, 6, I was trying to explain, my lord, that test of claiming through and under. Let us read that. As stated in Section 2 of these submissions, the court in chloro controls relied on the words claiming through or under appearing in Section 45, subsequently also inserted in Section 8, to conclude that Section 45 contemplates reference of non-signatories to arbitration. As stated above, the court in chloro controls recognize the category of persons who would be persons claiming through or under. These are persons who claim in the same capacity as the parties under or through which they claim, such as assignee or successor in interest. As held in Sharon Properties, the expression claiming through and under directs attention to the source of the right and is a legislative recognition of the doctrine that an arbitral award binds every person whose capacity or position is derived from and is the same as the party in the proceedings. There's a similar reasoning, in 20, which is the Australian. But your lordships in paragraph 20, Sharon, laid out what it is mean to mean acting through or under. The cause of action of such instance is derived from a party to the other. They do not claim an independent right based on the implied consent to the contract. However, in chloro controls, the persons sought to be brought within the ambit of arbitration were separate corporate persons who claimed independent rights under separate agreements. These persons were not claiming through or under the party, but rather claiming independently in their own right. If a doctrine of group of companies is articulated in chloro controls, cannot be traced from the phrase claiming through or under. At the highest, it may be contended that parties to an ancillary agreement have incorporated by reference the arbitration agreement contained in the parent agreement on the basis that the parent agreement references the ancillary agreement or annexes a form of that ancillary agreement to the parent agreement. This is also part of the reasoning in chloro. However, the arbitration agreement contained in the parent agreement can be incorporated into the ancillary agreement only to the extent that the ancillary agreement does not itself contain a separate arbitration agreement. Therefore, to the extent this was done in chloro controls, despite a separate, distinct, and different dispute resolution clause in a particular ancillary agreement, I just want to respectfully submit that even that aspect of the decision is required to be. Therefore, these are my submissions, first on Section 7, then on Section 5. But I'll rush through this next section, which is, that in earlier decisions, your lordships have articulated what it means to have an arbitration. And it's my respectful submission that the hasn't dealt with those decisions fully. Paragraph 13. We submitted that chloro controls is required to be overruled also because it did not adequately consider or contend with the previous decisions of this court on the subject. But in Wellington Associates versus Kirit Mehta, the court held that Section 7 of the Arbitration Act required the agreement must necessarily or mandatorily require the appointment of an arbitrator. Jagdish Chandra, I may just come to the italicized portion. The intention of the parties to enter into an arbitration agreement shall have to be gathered from the terms of the agreement. And that if the terms of the agreement clearly indicate an intention on the part of the parties to the agreement to refer their disputes to a private tribunal for notification and a willingness to be bound by the principle of such tribunal and such disputes, it is an arbitration agreement. But I'm placing emphasis on the fact that the lordship held that to enter into an arbitration agreement, that intention has to be gathered from the terms of the agreement, not implied. It has to be gathered from the terms of the agreement. And the court further held that while there is no specific form of an arbitration agreement, the words used should disclose a determination and obligation to go to arbitration and not merely contemplate the possibility of going for arbitration. Then, your lordship, paragraph 34 was Sukanya. The court will distinguish Sukanya on the basis that at that time, Section 8 did not provide for persons claiming through or under. But at the end of paragraph 35, therefore, I make submission in the last 5 lines. It underscores that the court in chloro control relied entirely on the language of Section 45 of the Arbitration Act to justify the group of companies doctrine without considering whether such input is consistent with the definition of an arbitration agreement in Section 7. But there was a similar issue that arose in Indo-Wind, and this was not the case. The court also did not refer to or consider the Indo-Wind was wherein an arbitration agreement entered into by two companies was sought to be extended to a third company. Indo-Wind, on the grounds that Subhuti was a promoter of Indo-Wind and that the person who had signed the agreement on behalf of Subhuti was also a director of Indo-Wind. The court rejected these conditions, stating that if the director who signed on behalf of Subhuti was also a director of Indo-Wind, and if the intention of the parties that Indo-Wind should be bound by the agreement, nothing prevented Westcare insisting that Indo-Wind should be made a party to the agreement and requesting that the director who signed for Subhuti also to sign on behalf of Indo-Wind. This is in some senses the heart of the case, that there is nothing that prevents parties from insisting that that non-signatory sign the agreement at the relevant time. The court also dismissed the attempt to draw an inference that Indo-Wind party to the arbitration agreement from the conduct of the parties, holding that while an ordinary contract may be entered into oral or spelled out from correspondence, the same cannot be said. The court held that if Section 7 says that an arbitration agreement should be writing, it will not be sufficient for the petitioner in an application under Section 11 to show that there existed an agreement or that Indo-Wind had transacted with Westcare or Westcare had performed certain acts with reference to Indo-Wind as proof of an arbitration agreement. And I just want to spend a little time on this aspect, on performance. Again, performance must be performance of a corporate entity as a corporate entity. It can't be without in my submission that just by an employee writing a letter or an email saying that I understand that the services agreement with SAP India has some difficulties, we are working to iron out those difficulties. That contract then is taken over by SAP. But therefore, performance.
It said that we'll take care of the issue.
Yes.
Something to that effect.
Yes.
So when you say take care, what would it mean? That the subsidiary in India is not able to take care and will take care? Well, of course, you have said that it may not be a letter written by the company itself, but one of the person on the company.
Yes.
But then the person to whom the promise was made or the assurance was given, they would go by that understanding that the principal has said that we'll take care of the issue.
Tax lordships are not going into that fully. Of course, the email originated from Cox and Kings. What that correspondence can mean, in my respectful submission, at the highest, is that we will look into how SAP India is executing this contract. Kindly similar, by that way, SAP Germany is not going to start receiving consideration for the contract. The consideration that is flowing. Therefore, the entire performance is still by SAP India. Qua Cox and Kings. Cox and Kings has no relationship with SAP Germany. I dare say they have no contract.
That's right.
But they actually will not have no legal relationship, although that's a matter separate. That is a separate matter from the arbitration agreement. But what is being done in instances like that is really someone senior in the organization is saying that we will talk to our colleagues in SAP India and they will execute the contract. I hope I make myself clear.
No, because we may not exactly go into the facts here and precise correspondence. But suppose the correspondence is such an issue which is arising between A and B, and C, which is the German parent company, C says that we'll take care of it.
Yes. Again, that is an email authored by a particular employee.
No, let's not go into precise the facts.
I appreciate it. The submission related to that, what we talking then of an assignment of the contract or even an ovation. And if that is what we are doing, then is that consistent with the terms of the contract itself? And it will not be consistent. That's why these issues would get a life of their own, in the sense that if this goes into an arbitration, Your Lordship is aware we can't challenge the Section 16 dismissal If Section 16 is filed before the arbitral tribunal and comes to be dismissed, then you have to participate in the arbitration through its entire journey. And you can challenge it in Section 34. And that's where, in some sense, the stakes are high. To not involve a party that is not a party to the arbitration agreement. And juxtapose with how do modern corporations transact? They transact through written contracts.
Threshold has to be very high.
Yes.
First and foremost.
The US and Germany are providing services in India.
I mean, suppose the facts are such that yes, it could be understood as a novation of the contract. Believe or do
Well, the entire team working on it would still be SAP India. I'm only saying
no, that of course.
that may not be what the person also understands. It is still the issue. But the person with whom we are is still always SAP India. We're escalating the issue. Someone will look into it, but the understanding may not be that simple that by just a letter you making it to SAP.
In golfing terms, if you use a rescue
Yes.
to get out of this tricky situation, the German company is saying, I'll rescue. What happens?
But I would only say the German company is the caddy who hands you the rescue.
Okay.
But you have to still hit the rescue club. And I'm only submitting this in the context of will affect modern corporations. And if they were to take party to an arbitration agreement, which is a seat not chosen, procedure not chosen, that may have some consequences, separate from the fact of what is they have entered into with Fox in this case. But if SAP Germany is faced with the situation, this case now not just that there's an arbitration agreement, but there is a contract or a claim against SAP Germany. And those are two separate issues, arbitration agreement and legal relationship. But the line is very clear. Ultimately, these parties that have made parties to the arbitration agreement to be made part of the main contract also. Ultimately, those are the claims that are being made. And I'm only respectfully submitting that would be done by a formal arbitration, in which case they would anyway be parties under the agreement, as well as paragraph 70 of the program. Where it is just a claim, it can't rise in my respectful submission to the threshold of innovation or an assignment of the contract. So I'll just place 38 because MR Engineers has a nice formulation of appropriate guardrails, perhaps. Para 38. Reference was made in chloro controls to Section 7.5 of the Arbitration Act and decisions of this court to incorporation by reference. However, the conditions subject to which a clause contained in one may be to be incorporated in another. In MR Engineers versus Somdat Builders, the court held that Section 7.5 requires conscious acceptance of the clause contained in other document, and a general reference to the other document is not enough. The court also held that the court would have to examine whether the intention of the parties was to incorporate the entire agreement or only a specific portion thereof. The court summarized the principles relating to incorporation as follows. General reference to a document containing an arbitration clause is not enough. A clear reference to the document containing an arbitration clause is necessary. The reference should indicate intention to incorporate the arbitration clause. Where a contract provides that its execution or performance shall be in terms of another contract, which contract also contains a provision of settlement of disputes by arbitration, the terms of the referred contract relating to execution performance alone would apply, and not the arbitration agreement contained, unless there is a specific reference to the arbitration clause. This requirement may not apply where the contract provides the standard form of terms and conditions of an independent trade or professional institution bind the parties, and such standard terms containing arbitration clause. And 5, the arbitration clause sought to be incorporated should be capable of application to dispute sought to be incorporated. This decision further supports the conclusion of this court has always required the parties put a firm undertaking of agreement, absent which an arbitration agreement will not be preferred. And then, my lord, chlorocontrol I've dealt with, my lord, at 158, use this expression of incorporated by reference. In the face of a contradictory dispute resolution clause, that, my lord, reference may not be. Finally, my lord, paragraph 41. The court question to refer a non
This could be the best.
So how long now, Mr.
Lord, 15 or 20 minutes. I'm conscious of my time. Lord, I'll just rush through some of these points.
You address us more on 7. 7 is a crucial part of it because everybody is focused on 7.
Yes, Lord, may I just go through this itself and I'll just complete in 15 minutes?
Yes.
Roman 8, Lord, of my written submissions.
Yeah, that's right.
Makes the point about the Law Commission recommendation.
That's right.
And Lord, at paragraph 45, I also narrate which other provisions of the Arbitration Act of party, which would all be impacted by this particular. Lord, I've already made briefly my submissions on the 4 cases, Lord, that are also concerned here, Lord, which followed chloro control. I'll just place on Charon properties, Lord. I may just read my discussion or my understanding of Charon properties.
Yes.
In this case, the court was considering a share purchase agreement which recognized the right of KCP to sell or transfer his holding in SPIL. This is important, provided the proposed transferees accepted the terms and conditions mentioned in this agreement. Similarly, the agreement itself contemplated a proposed transferee accepting the terms and conditions of the agreement. And it is pursuant to this share purchase agreement that KCP addressed a letter acting as the authorized signatory of Charon and making a clear and categoric reference to the share purchase agreement, and that's paragraph 32. In that context, and examining section 35 of the Arbitration Act, which makes an arbitral award final and binding on the parties and persons claiming under them respectively, this court rightly, Charon, nominee of cases, owned by the award, even if it was not a party to it. The decision, insofar as it refers to and relies on chloro, does so to negate the submission of the appellate, that is Charon, that the group of companies doctrine cannot be applied in this case. It is in that context that the court was asked to go into the group company doctrine. However, what is applied after the discussion of paragraphs 23 to 28 by the court, there was the group of companies if the phrase claim, because in this case, Charon property could only claim its right to the shares through KCP, who had suffered an award. So this is not.
So we held that Charon is really bound by the award which was rendered against KCP.
Yes.
Though Charon was not a party to the arbitration proceeding. Because Charon had the KCP, KCP had assumed the right to transfer its shareholding, provided the transferee agreed to be bound by the same terms and conditions. And Charon had expressly stated that it was bound.
Yes.
And therefore, it had assumed, because it had assumed this contractual obligation.
Yes.
Then the award also bound it. That's what we said.
Yes. I'm grateful. But I'm grateful. That's how I've understood that decision. And really, red herring of chloro control was raised, but actually it was a case of taking under because it was a assigning of. But Amit Rajchan has now adopted just the second part of that chloro control test. And merely because agreements are interlinked, parties have become bound by the arbitration agreement. And in this case, it was an unrelated party also. And therefore, I've submitted with respect that that decision may not be correct because I was extended it purely on the fact that there are interlinked contracts. And I just read from line 8 or 9, the issue that may arise. Line 9 or 10, this may best be illustrated with a simple example of a principal employer who engages a contractor pursuant to principal agreement. That contractor in turn engages one or more subcontractors under one or more separate subcontract agreements. Assuming the agreements contain separate arbitration clause, the mere fact that both sets of agreements relate to the same commercial project cannot be the basis to conclude that the subcontractors have agreed to be bound by the arbitration agreement contained in the principal agreement. To do so would defeat the expressed intent of the parties to be bound by that particular arbitration agreement entered into among them. And in the case of arbitration agreements that contemplate institutional arbitration, this would also impact relevant institutional rules of consolidation of arbitration. It would also have the effect of converting what would otherwise be a purely domestic arbitration into an international commercial arbitration, which in turn would determine whether the ground of patent illegality would be available to the parties to challenge the award. The submission here is when parties are, as in my case, SAP India and Fox and Kings, then it's not a domestic arbitration. Now, if you bring in a non-Indian party, to use the term, then you convert the character of that arbitration also. And that's where I come from when I submit that agreement has to be read a little carefully. But MTNL, Canfina was not a party to the agreement to arbitrate, and therefore I submit that decision may not have been made by the overruled. ONGC versus Discovery, Again, Lord, facts will be clear. In this case, ONGC had entered into a contract with the Discovery Enterprises Private Limited, but brought an arbitral claim against EPL and a sister company, Legal. ONGC also filed an application for discovery and information to make its case that there existed functional, financial, and economic unity between DEPL and JDIL. Without considering this application, the tribunal allowed JDIL for deletion. It was this section 16 set aside by the discovery application should have been decided first, especially as JDIL failed to produce. Tribunal's order was prior to this. The tribunal didn't have the benefit of fluoro control because it happened much later. Inasmuch as this was the basis for the decision of this documents produced by DEPL may have made out ONGC's alter ego. And since the case was remanded on the basis the tribunal did not have the benefit of this court's decision in fluoro control, the decision may not require reconsideration. Well, just very quickly, fluoro control erroneously states that English law supports the group of companies doctrine. There's no international consensus on the applicability and extent of the doctrine. But I've reproduced the definition of party from the English Arbitration Act. I've reproduced that definition, and your Lordship sees references in this part to a party to an arbitration agreement include any person claiming under or through a party to the agreement. And despite this, English law doesn't apply the group of companies doctrine. Importantly, Singapore, since it's such a poor arbitration, also, rejects forced jointers. The words used in that judgment are that it's a drastic. Similarly, the United States. Para 50 and 51, I've again just set out Dow Chemicals and explain that arbitral awards do not create a and also rendered under different laws that are not. Paragraph 11 of my submissions, again, I won't spend too much time on, but I'll just read out the heading. The submission of the group of companies can be discarded only if the Arbitration Act expressly prohibits it.
That was Dr. Singhvi's sir.
Just read that by saying, that section 5 says, as governed by this. And therefore, it must be found in section 7, 8, or 45. Go
to para 12, I think. That's your wrap up.
Yes, para 12. Rejecting the group of company doctrine advances arbitral practice and provides clarity. The following principles emerge from the discussion in the preceding sections. Arbitration requires consent as to the party's intention to arbitrate. This consent is provided by requiring an arbitration agreement be in writing. The intention of the parties must be gathered from the words used in the contract, and where those words are unambiguous, their plain meaning ought to be given effect to. Where the parties have incorporated into the underlying contract an entire agreement clause, the parties' previous negotiations cannot be relied on to discern whether the parties had an intention to bind any third party to the arbitration agreement. Of course, where there is a principal agreement and ancillary agreements arising therefrom, the arbitration clause contained in the principal agreement may be incorporated by reference into the ancillary agreements, provided that the ancillary agreements do not contain any inconsistent dispute resolution clause. However, this does not require the invocation of the group companies doctrine. In such a case, reliance will be placed on section 7, 5, and the law laid down in MR Engineers. Under Indian company law, an agreement entered into by one of the companies in a group cannot be binding on the other members of the same group, as each company is a separate legal entity which has separate legal rights and liabilities. I rely on Vodafone. Mr. Kambata has already argued. Therefore, my conclusion, the group of companies doctrine is inconsistent with these principles, and the principle of party autonomy is submitted to the doctrine, or from advancing arbitral practice, in fact, detracts from it. This is because it is a significant element of uncertainty and discretion in determining the persons bound by an arbitration clause. Consequences of this uncertainty are significant. If a person asserts that it is not a party to the arbitration agreement, that person will have first to have recourse to section 16, and if unsuccessful, will have to participate in the arbitration proceedings before challenging an award under section 4. If it is then determined that it had not impliedly consented to the arbitration agreement, the award would have to be set aside and parties relegated to civil court for adjudication of their disputes. There may be no easy answers in disputes that arise in the context of multiple parties or multiple agreements. That is why institutional rules also have separate rules for consolidation of disputes or jointer of parties. Ultimately, though, the answer ought only come from the terms of the arbitration agreements entered into between parties. if the parties have entered into distinct separate arbitration agreements, or as in the case of chloro control, dispute resolution clauses that contemplate adjudication by a civil court, or if there are persons who are not party to any arbitration agreement at all, there is no basis to consolidate all the disputes applying in the company's doctrine. It's therefore respectfully submitted that the doctrine ought to be held, if not valid, in Indian law. Well, I may just add one footnote. If your lordships consider the guardrails or prescribing or limiting the doctrine, my respectful submission would be that the second limb of chloro control, which says that when there is a commonality of the agreement, even absent this non-signatory consenting, principle can be employed. That part, my lord, may be too broad.
Right.
The first part of the chloro control test, my lord,
the mutual intent part.
Mutual intent, my lord, can be read in only in those cases where the group company is itself named in the contract as a party and actually performs the contract as a corporate entity.
Right.
The Dow Chemical kind of situation. So, my lord,
thank you so much, Mr.
Lord, I also appear in the matter that Dr. Singh appeared. Lord, I also appear on the other side. And that's just one sentence on that, Lord. That arose from a deed of family settlement, which was between certain individuals of my lord, the Kirloskar family. Dr. Singh's client, my lord, filed a suit arraying all the individuals and also various listed and unlisted companies of the Kirloskar group. So, in fact, my lord, they filed a suit recognizing perhaps that the group of companies doctrine would not capture this. They actually filed a suit. As it transpired, my lord, the companies whom I represent said, without prejudice to their argument that they are not parties to the family settlement, the contract, they are agreeable to go to arbitration. That is what, my lord, we gave in the Bombay High Court. So actually, my lord, that case doesn't really arise here because, in fact, they've taken opposite position.
Sir, we'll wrap up at this day and we'll take up now.
One last statement, as I said, that issue is the issue that Mr. Kambata addressed, whether individuals can bind listed companies. It doesn't really arise in this case. I just wanted to place that.
We'll start tomorrow with Diwan. Liz, you want to also argue? All right. You are instructing Mr. All right. So now the only submission left on this side is Mr. Diwan. George, you want to argue?
Intervention on National Committee on that.
Oh, you are appearing for the answer to our National Committee. So you will guide us dispassionately. You will be like a really and a mic is curated.
Yeah, just 10 to 15 minutes.
And Manoj, there's Mr. Sanjay Ghosh who says he'll take about 10 minutes. He was here in the afternoon.
No difficulty. Mr. George, you can give us whatever material you have,
Yeah.
You have filed that. All right. You have circulated because Uncitrial will have a lot of underlying material.
Yeah, I mean, just about
we would be happy to see that.
Relation with the New York Convention.
All right. So about half an hour for you tomorrow. Say about 11 o'clock to 11:30.
For me?
Yes. Now I think we have heard substantial arguments.
I had in fact anticipated about an hour and a half. Your lordships had told me that. So give me.
Now I think we'll wrap it up early because we have a special bench. We don't want to spill it over because next week we have another conference starting on.
What's up? You can just indicate to us.
Okay, we have to close now.
I'll certainly will try because I kept on cutting my cloth based on what was said.
If you have a good night's rest, I'm sure you can
No, I
consolidate further.
certainly will. If your lordship thinks I certainly don't intend to repeat anything that.
If you are tired like we are when we start dictating judgments, it will be very long.
Correct. But, so there are a couple of other facets which, in fact,
You're fresh. That's why my brother says, then it will be brief and.
No, I certainly will. I don't think your lordship has ever seen me.
So half an hour, and then George, 15 minutes for you.
Because I'm certain I won't be done in half an hour. There are certain aspects of
20 minutes.
If your lordship is cutting,
Raman, yeah.
because your lordship may give me at least an hour and a half.
At least an hour and a half.
I'm so grateful.
In the early days of Gojek, there was a lot of resistance to our services. The most common form of that resistance in the early days was actually by motorcycle taxi mafias. So you would have like these areas that are essentially controlled through violence by specific, area mafias. And when we